Hello, you have Ted Corliss with the Corliss Law Group. Today's media relates to the issue of turnover of condominium developments. We'll explain that in just a moment, and after that, we'll jump into a conversation between a professional engineer and a condominium lawyer. What is a turnover in the context of a condominium? Well, what it means is, imagine you are a real estate developer and you have the resources and wherewithal to construct a 25-story building. That building at some point in the future will be then sold to individual unit owners, and at some point in time, the developer or the construction company will turn over the building to a board of directors who will then become primarily responsible for the maintenance and upkeep of the facility. The issues associated with these are obvious, first and foremost being that what if the developer is aware of individual issues that are latent or hidden from inspection, yet turns the property over to an unknowing board of directors. And so you can see the kinds of problems and at a minimum understand the issues that boards of directors should be aware of when being placed in the turnover environment. In just a second, we're going to jump into a conversation between Byron Anderson, a professional engineer, as well as Dan Greenberg.
Good afternoon. I'm Byron Anderson with Structural Engineering and Inspections, and I have with me here today Dan Greenberg. He is a Condo Association attorney, and we're going to take a few moments to discuss with you the crossover between engineering and legal aspects of condo associations, condo buildings, the repair and maintenance of those buildings, things of that nature. So, Dan, would you like to say good afternoon?
Thanks, Byron. Hi, everybody. Good afternoon.
Very good. So before we got on, we were kind of talking about few key items that we wanted to discuss, and I think that you were asking me about turnover studies, right? And from a legal perspective, can you tell me what a turnover study is?
Yeah. So the main concern I have as general counsel for associations and not being a construction defect specialist attorney is that much like my boards that I inherit after turnover, I am largely unaware of what potential issues structurally may be occurring in the portions of the building that are not evident to us just from outside visual inspection. So when I take over a community as new attorney for a newly turned over community, the first conversation that I have with the board is typically, how do we address the health of your building and your structures? And oftentimes what I hear back from the board is that, well, we've had conversations with the developer. They presented us with some materials. We haven't had any, terrible problems. They fixed a couple things over here, the roads and some curbing, and they fixed an irrigation system over on this part of the property. And I think everything else is okay. And my response to them always is that, neither you or I are in position to determine whether or not this building is okay or anywhere close to okay. And unfortunately, what we run into with newly turned over communities is typically A, lack of understanding of even running a condominium, and B, lack of sufficient funding because developers, oftentimes will kind of leave the community, not in bad shape necessarily, but, in a starting position. So with a newly turned over community and a newly installed board coming from square one, the last thing that they're thinking about is sinking costs into testing of buildings that in their mind are essentially brand new.
Sure.
And particularly if they haven't been experiencing issues, water intrusion and the like, that they've addressed with the developer. They are assuming that this building that they now own and control is in good health. And unfortunately, that's a conversation that we have to have with them as to why things aren't necessarily always as they appear.
Sure. Well, the one thing I would say is that, and I'm trying not to be cynical here at all, but developers their role is to develop property and then sell it for as much money as they can possibly make, right? And oftentimes they are also instrumental in getting this turnover study. And just so that we're on the same page, a turnover study really has two purposes from my perspective. Its first purpose would be to give a condition assessment of the building, identify things that should be fixed by the developer or repaired by the developer prior to the association taking control of the building. And then the second thing that the turnover study should do is it should set reserves based on life expectancy of various components of the building, i.e. roofing, i.e. parking, etc., and then what the replacement cost values are. And so the idea is that you could project forward how much money you're going to need to not only maintain, but also provide capital improvements or capital repairs as necessary in the future. The issue that I have is that if the developer is part of the team that is doing that turnover study, then there's an inherent bias or problem associated with that, and that they don't want an unfavorable turnover study. They don't want a turnover study that overfunds things, because that means that the monthly fees are going to be greater, which is going to reduce the selling cost that they can get for that individual unit. So my experience has been is that oftentimes turnover studies lack the clarity and the definition and the foresight necessary to adequately address both of those items that they were supposed to address. Oftentimes they miss obvious building code deficiencies, and oftentimes they underestimate costs associated with maintenance and with turnover. So do you have anything else to say about turnover studies?
No, I think that's totally accurate. I think the biggest issue or red herring is when the association gets a clean bill of health, so to speak, from the developer. It's psychological as much as anything. They want to believe that study because it helps them feel at ease about the place that they live. And we hear this a lot. Same with insurance. They file a claim gets denied. Association assumes that this insurance company who works for them, who purportedly represents them, is going to tell them the truth and is going to act with the utmost of ethical and legal considerations, which we unfortunately know is sometimes not the case. Same is true with developers. There are many, many great developers who do a good job, who have good intentions, but there are also those that do not, whether intentionally or unintentionally. So the main advice I would give to any board member who's listening right now is to not take everything that you receive from the developer for granted. Unfortunately, oftentimes we are going to need a second opinion, and we hope that the second opinion confirms what the developer is telling us. The reason why it's so critical to get that second opinion, though, is so that we can have ultimate peace of mind.
Correct.
We can have neutral peace of mind, an evaluation by a professional that we know works for us and in our best interest. And so that initial expense to undertake that study and get that second opinion, I think, is of tremendous value to the association, both presently and moving forward.
Absolutely. And moving forward brings us to the second topic that I wanted to discuss with you today, and that was statutory repose and construction defect. Actually, I guess it's two different subjects, but they're intertwined there. You know, one of the things that has been discussed before, and I think it's a salient point, is that the statutory repose in Florida is currently 10 years. There's been push in the Florida legislation several different times in the past couple of years to reduce that down from 10 years, which I think is a huge mistake. Reducing it down causes me great concern because the vast majority of the construction defect claims that we are involved in from an engineering perspective actually do not become visible or apparent until years 7, 8, 9, 10, 11, 12, 13, 14. Well, it's imperative that that 10-year mark is ingrained in associations and in owners, that you need to make sure that if you're going over that line, that there's no construction deficiencies that are going to come back and bite you shortly thereafter. I mean, one of the worst cases that we're involved in currently, there were construction deficiencies that became apparent in phase 1 of the project before they were even completing phase 2 of the project, yet they did nothing to change the construction methodologies to address those construction deficiencies in phase 2. What I would say to associations and to condo and really any building owners is that there are things that can be done prior to that 10 years to potentially identify construction deficiencies before they have gotten to a point that they have caused significant damage, collapse, or some other type of problem to a building. And those steps generally would include someone like myself, a design professional, engineer, architect, reviewing the construction documents for construction deficiencies. Were there adequate details that were put forth for waterproofing the envelope during initial construction? Were those details followed? Were manufacturers' recommendations followed? Followed by an inspection of the property. Oftentimes, someone like myself or my company, we can identify construction defects just by doing a visual inspection without having to cut into the wall, just because we know specifically what we're looking at, and we've seen the damage that occurs from these construction deficiencies many times. Reviewing the design concept of the building, how is it supposed to be operating? One of the things that I really wanted to talk to you about as well is there are different risk factors associated with a building. When I say risk factors, the analogy that we were using earlier is that your building is a patient. Well, patients have different risk factors associated with weight, blood pressure, diet, exercise, things of that nature, genetics. Well, a building also is going to have various risk factors. Those risk factors are going to be based on its building type. Is it a all masonry building with many supporting bearing walls? Or is it a building similar to Surfside, in which we had concrete columns supporting two-way slabs, which have a critical punching shear element around them, which can lead to catastrophic failure? Is it a frame building? Probably one of my biggest concerns as a structural engineer and a general contractor looking out over the landscape is seeing all these multi-story, 4, 5-story wood frame buildings, residential buildings being constructed, oftentimes being covered in stucco. Those are a recipe for disaster. I mean, we're currently working on 6-story building right now that's all wood frame, that's about 7 years old and has millions of dollars of water damage and water rot to the wood framing it's hidden because it's behind the cladding, but nonetheless it is occurring and causing structural degradation. So your building type is a major risk factor. Your location is a major risk factor as well. Are you located right on the beach, on the ocean line, where you're getting saltwater spray onto the building? Or are you located more inland? So that's also a risk factor. The age of the building is a risk factor. And then the maintenance and maintenance history associated with the building. If you let maintenance go or slide, then you're going to be more apt to have significant problems associated with that. So, really, I think that understanding what the risk factor of your building is, understanding what your condition of the building is prior to getting into that 10-year statute of repose is important. And then going beyond that 10-year statute of repose, making sure that you're doing routine inspections and documenting the condition of your building on a regular basis. And I would say as important as anything is maintaining good maintenance records, because one of the things as engineers that we're looking at your building for some sort of a repair, some sort of a problem, we're going to want to know what the maintenance is and what's done from a maintenance perspective.
And I can tell you that from practical experience, we should do our very best to block out this 10-year concept at all and address it in year one. And the reason being is multifold. I highly doubt that most condominiums are going to have the appetite for this level of inspection in year 7, 8, 9, 10 of the building. At that point, they have already settled into regular habits. They've established budgets that owners have come to expect and have structured their finances around. They're now dealing with the types of minutia that takes up 90% of the board's time with just typical operational type concerns and violations and dealing with the type of problems that people think of on a day-to-day basis. The last thing that a condominium in year 7, 8, 9 wants to think about is the safety and structural integrity of their building. It's a thing they've already taken for granted, and it is not a thing that they have budgeted for. So if we can strike when the iron is hot, soon after turnover in year 1 or 2, not only are we, or should be, in the mode that, hey, how do we protect this asset? Because when I counsel new associations I take on after turnover, we need to be thinking about setting policies, practices, and procedures that will set us up for success in the future. And also at this time, before it's gone too far, is thinking about the actual physical structure of the building itself. So not only do we have the appetite to do it more so in the beginning, but also in doing that, in diagnosing earlier, we can save a lot of headache on the back end. Not only do we run into, obvious evidentiary type of issues potentially years and years down the road, but we also have exacerbation of damage that could have been caught in the beginning and maybe helped us manage that project a little bit easier, kept costs down. Maybe the developer is going to be more inclined to make a $100,000 fix than $1 million fix. And obviously sometimes it's just going to be a complete structural issue that you're going to tell a group that you've got a major problem and there was something fundamentally wrong, with this building. But, more often than not, I think we're dealing with minor-ish issues, which are still issues, but that if not addressed early are going to turn into bigger issues. Whether we've got window type issues or a roof type issue, that's something that could be easily corrected in many cases and save us a whole lot of headache and expense down the road. So we have to strike when the iron is hot. And unfortunately, we just don't have the system in place right now for boards to know who to even turn to. And what they should be doing, because the first call they're making is typically not to the engineer.
Yes.
They're calling the landscaper, and they're calling the pest control guy, and they're making sure the pool's going to be cleaned, and they're making sure that the windows are going to be washed and everything else. So it's they don't want to talk to you, Byron, and it's not your fault. They don't want to know that there's a problem. They don't want to be thinking about these huge big ticket items. It takes hearing from professionals like us to clue them into the fact that this is something that is part of the board's fiduciary duty, whether they know it or not, whether they like it or not, whether the membership likes it or not. It comes part and parcel with running a condominium, period.
I want to take a moment to thank both Dan Greenberg and Byron Anderson for sharing their insight into the turnover process. If you are in need of services associated with property damage, especially disputes with insurance companies, and you're either a licensed community association manager, you're either on a board of directors, or you're a condo unit owner who has concerns about the condition of their property. If you fit that profile, please join us at the corliss.lawgroup.com website, where we can provide additional information on how we may be able to help you. Be well.